Wait for a while, Vijay sir.
Yes,
Wait
ma'am.
for a while.
Yes.
Yes, Vijay sir. You can go.
Good evening, everyone. Distinguished resource persons of the day, Professor Sandeep Desai, Professor and Dean, Amity Law School, Bangalore, respected Principal Dr. K.B. Kempegowda sir, my esteemed colleagues and dear participants. I am Dr. Vijay, an Assistant Professor and Coordinator, Faculty Development Program. It is my privilege to welcome you all to the Day 6 of 7-day Faculty Development Program on the new labor codes. Today we have with us a distinguished resource person, Professor Sandeep Desai, Professor and Dean, Amity Law School, Bangalore. It is my honor to present a brief profile of our esteemed resource person. Sir was born and raised in Dharwad, the Vidyakasi. Dr. Sandeep has been a rank student from his school days through the board exams to the university days. He secured 5th rank in the pre-university board exam, 1st rank in LLM, and was awarded the gold medal for securing distinction. He has a PhD in agricultural patents conferred by Karnataka University, Dharwad. With an experience of more than 25 years in academic and 7 years in profession, Dr. Sandeep has founded and nurtured a law school in Christ University, PS University, and Presidency University. Currently is serving as the founding Dean of Amity Law School, Amity University, Bangalore. In this long odyssey, he has served on committees like Dr. Justice V.S. Malimat Committee on Criminal Justice Reforms, Committee for Action Plan for Legal Education of Government of Karnataka, and others. Recently, he has submitted 13 model bills to the Kilpar Bangalore as part of their ambitious project of having a bill bank for the state of Karnataka. Along with this, he has produced a major research project on health law and been to Hong Kong as a part of the academic consultation program. That apart, he is a member of several board of studies and doctoral committees. He has successfully guided 3 PhD scholars and presently 4 scholars are working under his guidance. He is a regular resource person to many prestigious law school and universities. Dr. Sandeep has published widely in leading journals and is on their editorial board too. He is an avid contributor to the legal service clinics and legal aid movement wherever he has worked. It is punctual to promote the moot culture. With this brief introduction, Sir has accepted our invitation and agreed to deliver a lecture on prophecies and fallacies of the labor codes. Sir, I, on behalf of the Janata Education Societies, Vivekananda College of Law, and on behalf of all the participants, a warm welcome on this occasion, sir. And I take this opportunity to welcome Dr. K.B. Kempegowda, sir, Principal Vivekananda College of Law, Bangalore, on this occasion. And also I welcome my dear colleagues and dear participant on this occasion. Over to you, sir.
Thank you, sir. Thank you for the kind words that you have spoken about me. And at the outset, let me thank Dr. K.B. Kempegowda, sir, and Dr. Bhuneshwari for having invited me to be part of this faculty development program. It is always a pleasure to talk to colleagues, to talk to fraternity people, and share our thoughts, our viewpoints, especially on contemporary matters. So when Sir asked me to talk about the new labor codes, I was very happy because this is one of the areas that has been making news since its inception. I should say some 5 to 6 years back, from 2019 or 2020 onwards. The fact that it coincided with COVID, well, should we take it as any kind of omen? Well, that I leave it to labor law teachers, because labor law as such is an area. It is a discipline which has carved out a niche for itself in much the same way as the trade unions, as the laborers in India as well as in the rest of the world have made out a position for themselves. They have also struggled. Labor law as a discipline has also struggled, especially in the post-LPG era, that is liberalization, privatization, and globalization era, labor as a field, as a discipline, as a force have struggled a lot. So I just, was curious to know how these new labor codes would be shaping up the Indian jurisprudence, especially because when it comes to labor law, we all, especially those who have specialized in the area of labor law and who have taught labor law, who have worked in the area of labor law, we know the kind of unique jurisprudence that is advocated by our apex court and various high courts. So let me begin this talk with one quote. I quote, "To justify the study of comparative public law will not be more difficult than to prove the proverbial pudding or pudding, as the American jurists would say." Let me repeat. To justify the study of comparative public law will not be more difficult than to prove the proverbial pudding. Just replace the word comparative public law with labor law. In order to understand how a pudding tastes, the only way is to eat it and experience it. And in order to understand the ramifications of labor law and presently the new labor codes, the only way is to read them, analyze them, try to understand them, and then decide whether they are an improvement over the earlier labor law or different labor laws that we had, or whether the new labor codes have maintained the status quo, or whether the new labor codes have become more regressive than the earlier labor laws were. In order to understand these things, it would always be uh, advisable, it would always be welcome to basically read them and understand them and analyze them. As to taste a pudding, you will have to eat it. Remember, this quote was given by the noted jurist Ehrlich in the year 1921, that is 105 years ago, when basically comparative public law was becoming a buzzword in the area of law. So even after these 105 years, when we start discussing about comparative public law, we always start with this quote. In much the same way, I thought that we should start with this quote and replacing the word comparative public law with the word labor law to understand the enormity of this particular discipline. We all know that labor law is in a very unique way distinct for both the labor law students, labor law teachers, labor law practitioners. It is one area which is neither fully falling in the domain of public law nor in the arena of private law. It would be apt to call it, in my opinion, a sui generis law, a hybrid law, because it has the connotations of both public as well as private laws. Because when it comes to the idea of choosing, choice, basically between the employer and the employee, or as they used to be called, workmen earlier, it definitely would be in the arena of private law, because they would seek the employment, or the employer is offering. So there is a contract of employment, so on and so forth. But when it comes to regulation of these relations, at least under the erstwhile labor law, well, they were very typically regulated by various governmental agencies, inspectors, labor courts, industrial tribunal, so on and so forth. So it is basically a very hybrid kind of law, having the points of both the public and private spheres. And we all know that labor law as such gained momentum in the wake of industrialization in Europe, especially after 15th and 16th centuries, when the greedy employers started exploiting the labor in the very beginning without paying them, making them, forced labor. And that is how slowly there was a sort of awareness in the minds of laborers that they cannot survive like this. And that is how they started organizing themselves. Trade unions slowly started, gathering the necessary momentum. And finally, by 18th, 19th centuries, the United Kingdom, England, basically had developed, let us say, a roughly cogent and a reasonably developed labor law. I'm using the word reasonably developed because labor relations have never been peaceful relations. Whether in the 15th century or the late 18th and 19th centuries, or let us say in the present century, labor relations have never been peaceful ones. It has always been a fact that conflicts have been the order of the day. In fact, that's why it is said that conflicts are as old as hills when it comes to labor law. So the basic idea is that whatever the labor force have achieved right from 15th century onwards, well, it is all on account of basically the hard struggle and the hard-won victory. The question is whether these victories have really transformed the lives of laborers in the world to an extent that whatever the great trade union leaders have dreamt of or had thought of, including the venerated Karl Marx, whether that particular utopian state has been given to laborers at any point of time. If this question were to be posed, well, the answer is no. Because whatever they have done, it has not completely stopped the conflicts between the employers and employees. When the employees try to find various ways and means to, sort of negotiate, conciliate with the employers on an equal footing, the history is witness to the fact that employers have also tried to thwart those attempts. They have done a lot of maneuvering to avoid, to prevent the employees from getting the necessary benefits. So this conflict has been going on from 15th century onwards. And it is indeed unfortunate that the conflict has continued even to this day in one or the other way. That's why when I thought that I would speak about the prophecies and fallacies of the new labor codes, let me speak a bit about this historical background and then, come to the main point. Anyone who wants to understand labor law should basically go with the philosophical foundations that the labor law has come up with always. You can see that basically when it comes to labor law, there have been many philosophical arguments. There are, for example, 5 points that we all know and remember. Number 1, it speaks of distributive justice. Number 2, non-exploitation. Number 3, dignity. Number 4, citizenship, something which is very hotly debated in our country today with passport, whether it is basically a document of citizenship or not. That has been the hottest debating topic in India today. And of course, most important is social inclusion. These are the 5 typically philosophical vibrating points that have shaped the idea of labor law. Not only that, there are many other arguments in order to understand how labor law has worked right from the beginning. For example, the argument from the point of view of freedom, and the argument from equity and social justice, the argument from non-commodification, from paternalism, and from equal autonomy. Now, the point is, when it comes to all these philosophical arguments, philosophical justifications, the basic question is whether these justifications have really impacted the lives of laborers, whether we are talking of 15th century or 21st century. All these philosophical justifications can be clubbed into or can be understood through 2 arguments. Number 1, what we call the chimerical philosopher's stone. I'm sure you all know about alchemy. That is a science which turns the stones into gold. That is alchemist's job. So one idea is that philosophers have this chimerical stone which will help transform the lives of laborers into utopian state straight away, without any hassles, without any conflicts. This is one argument. The other is obviously what is known as the muscle and blood argument from the employer's point of view, because they feel that it is their money which is being invested into industries, and naturally they ought to have a say as to how that money has to be utilized, how much of that has to be parted with and given to the employees or laborers. And it is basically the muscle and blood of employees or laborers which are suppressed, which are sort of exterminated, which are sort of pressurized, and the laborers are to use their muscle and blood to come up with the benefits for the employers, out of which the employer would give whatever he or they deem fit. Many of the jurists say that neither of these arguments has anyway benefited the laborers to the fullest extent possible. Because the first philosopher's chimerical stone, well, that alchemist's argument can never become a reality, since conflicts are bound to be there, because human tendency is like that. So you cannot expect a magic wand to simply help coming up with an easy way to transform the lives of laborers and make it all look like Ram Rajya. And the other one, muscle and blood, obviously it speaks about sort of pressurizing the workmen to work for lesser wages or no wages. Many a time, at least in the beginning, working for 14 hours a day, 18 hours a day, so on and so forth, and wages were not paid. And I mean, all you labor law teachers would have read all these things that have emanated from the 15th century industrialization. So jurists are of the opinion that neither of these has anyway helped. In fact, so much so that when it comes to the second theory or the second argument, muscle and blood, especially after the liberalization, privatization, and globalization, it has so happened that the unions have tended to identify themselves with their persecutors, with their harassers, like a Stockholm syndrome, where a kidnapped person, where an abducted person would fall in love with the kidnapper or the abductor. So much so that there have been divisions among the unions to the extent that some unions are, especially in a country like the United States, some unions are managed by the immigrants and some are managed by the localites. And so localites would support the local employers, and the immigrants or unions held by immigrants were looked down upon. So the point is, whether you take the first argument or the second argument, there has been no special concession or benefit accruing from to help the laborers. Well, on the contrary, has it helped the employers? Well, the answer is again no, because there is not a single employer on the face of the earth who has not faced a labor unrest at least once or twice in his entire career. We don't have those kind of employers who have always been happy with their workforce and there were absolutely no issues at all. So throughout their careers, throughout their industrial careers, employers have also been unhappy. So point then is, what sort of labor law or labor legislation, or today we speak of labor codes, would help us or should help us, or what kind of labor codes would definitely try to bring what we call a utopian state. So with this background, I thought we would venture into the analysis of labor codes and try to see what they actually promised before they were ushered in, before they were made, and what or how many of those promises they could actually realize, or we could experience them, and how many pitfalls were there, and whether those pitfalls were sort of remedied or they still continue to haunt us. So this is how I am trying to present before you an analysis of these labor codes as to what were the prophecies that were made when the talk of overhauling the earlier labor law with an all brand new labor codes was talked about. So we all know that it was basically around 2019 and in 2020 when the existing 29 labor legislation were removed and 4 codes, labor codes, were brought in. Of course, many a battle, many an academic battle, many a labor battle were fought in between before in 2025 finally the government came out with final notifications saying that from November 2025 we would all be governed by the new labor codes. So what prophecies were made? What promises were there? And what perils followed? Well, this is how we would like to, I would like to look into. Now, when it comes to the promises part or the prophecies part, probably the first important thing that these codes have ushered in is bringing the otherwise unrepresented, unorganized sectors into the fold of labor law. So much so that today's platform workers like Swiggy, Zomato, and such others they are also being covered, even if to some little or partial extent, by the labor law. We never had, or the labor force never had that opportunity to be, sort of represented as part of labor law for these unorganized workers. So first important point is that basically when it comes to the new labor codes, the most important thing is, well, these unorganized labor force, which currently would be somewhere around, let us say, 560 million or so. Well, they are going to be represented at least in the arena of social security code, if not in all codes. That is one of the most important, points that this thing has brought, these codes have brought. The second important point, the second prophecy or the promise that we have been made was that the gig workers would be given a representation, a fair representation under the new labor codes. Well, that has also become a reality, again to some extent, a partial extent. I am not saying that everybody, every gig worker has been given an a representation, full representation to understand this. But yes, there have been um, provisions in the Social Security Code, especially, like for example, they can also now get the medical facilities under the Employee State Insurance Corporation. They can get regular health checkups. They can get the basic, sort of leave. In fact, they have also been promised that in case of accidents and others, compensation would also be considered, so on and so forth. Whatever it is, to what extent it will be given, or whether it will be given to the fullest extent possible or not, well, that is a debatable point. But most important thing is, there is a promise to cover them, which was not at all heard of earlier. But remember, we had specific laws dealing with, for example, the BD workers earlier. We had Contract Labor Act earlier. Now in the new codes, these have gone. So there is a point which I'll come to a little later. Point being that what is given, from one hand to cover majority of unorganized workers has actually deprived those who were already to some extent covered with the help of specific laws. Anyway, that we will come to a little later. So first thing is, we should keep in mind that these people have been covered. The first gig workers, as well as the most important is the platform workers, like Zomato, Swiggy, and others. The third important point that is helping the workforce is employers are now duty bound or mandated to provide the necessary employment documents, offer letters, schedules, payments, and a single point of registration. Everything has to be done, digitally, so that records are, maintained in a transparent way. All these are brought about. That is another welcome step which these codes are bringing, because there is only one point of registration, there is one point of contact. Working hours are mentioned, such that the moment a worker goes for an overtime, he is automatically going to be paid. Because earlier there was huge debate as to whether he had actually gone for overtime work or not. That had to be supervised by the supervisor. And there were many issues like that. But now, because of these developments, because of digitization and the social security network becoming more and more comprehensive, it is possible that these workers are getting into more formal, mode. That's the third point. The fourth point is, when it comes to these gig workers and various of these platform workers, like most of the organized workers, they are also contributing these days towards provident fund, towards other benefits, and most importantly, they are being recognized. That point of recognition in itself will go a long way in maintaining the dignity of the workers, because we all have studied how even under the earlier system, the independent contractors, they were not really treated on par with the full-time workforce or registered or regular workforce. So that very first legalization and recognition of these gig workers, that goes to give a lot of emotional and psychological satisfaction, a kind of reassurance to these workers. And that is probably the most important thing that we should remember. That is one of the points we should know. Now, in alliance with this comes the point, like, for example, the payment of gratuity. One of the most contested matters in Indian labor jurisprudence is the payment of gratuity. Most of us also were not in a position to, appreciate or advise the people whenever they asked, because the usual point is, well, only when you would put in 5-year continuous service in an organization would you be eligible for payment of gratuity. This was the general understanding. Now, we all know how that term continuous service has been interpreted. So there was a possibility, for example, when it comes to, let us say, an employer terminating an employee or a workman, let us say after 4 years and 11 months. Obviously, the worker or the workman or the employee was not in a position to get the necessary gratuity. Of course, there were courts. Courts have been there, or it may be labor courts, industrial tribunals, or the regular courts. But we all know how difficult it was for these workmen to approach these tribunals, these various agencies, and sort of get the necessary relief, because technically he was not eligible. And termination, dismissal, discharge, various terminologies have been used by the employers, to put them in such a situation that the workmen would not get the necessary benefit. But now, according to the new codes, this is reduced to 1 year. So after 1 year's service, if he doesn't want, well, he can get out, hop from one to another job, and still get the gratuity for that year. Of course, one might definitely ask, well, the employer might dismiss him even before 1 year, after 10 months. Well, yes, there is no end to such thinking, but at least having worked for 4 years, 11 months, or 10 months, and then suddenly you are asked to go out without gratuity or without any other eligible payments, how does it feel? Then you compare yourself with this 1 year, you take your provident fund, get out and get to another better, greener pasture, as we call them, in literature, greener pasture. Naturally, it will bolster the spirit of the workman. So that is another important point, another important promise that these new codes are giving. That's another important thing. Now, sorry. Most important again is that these labor codes are coming up with, or they have come up with, what we call gender equity adjustments. We all know, for example, how it was impossible for women to work in night shifts earlier. I still remember, let us say, after around 2008 and 10, during that period, let us say some 15, 16 years ago, slowly a few states started allowing night shift for women, night shift working, but with a lot of conditions, and so much so that probably they weren't really encouraged to do that, only because of the fact that they were women workers. It was definitely a discriminatory practice. It was definitely a discriminatory approach. And that could have been very well addressed when the liberalization, privatization, and globalization started taking shape. But as with most of the patriarchal societies, women workers never got their due at that moment. But now, these codes, especially the Social Security Code, it makes it sort of mandatory on the employers to create the necessary, healthy, and safe working conditions for women workers if they want to do night shift. So there is a transformation from the attitudinal point of view, a thing which once was considered, let us say, an anathema, right? Something that is not acceptable socially and legally at one point of time. Well, now these courts are trying to compensate that. And now the employers cannot say, well, if I employ a woman worker, well, safety would be a concern, and I do not want to invite trouble, so on and so forth, because primarily the onus is now, sort of put on the employer to create that necessary safe and healthy working condition for women workers. And you also know that these days the maternity benefit has also been extended to a very considerable extent of 26 weeks, almost, sort of 6 months. We all have studied at one point of time that it was just 1 month, and in some cases it was converted into 3 months. And even to avail those 3 months, it was a Herculean task for women workers, to claim it as a matter of right. But these days, as we all know, maternity benefit is also extended, and these codes now, they urge the employers to create that suitable working conditions for women workforce so that they will not be left behind in any ways in sort of competing with the men. So basically, these are some of the important points that were sort of promised, that were prophesied at one point of time before these codes became a reality, and right now also they have been promising these things. In addition to this, of course, there are many others also. For example, if you have a close look at all these things, you can see that the employee can get his hiring documents right from the day one to maybe the day of going out, with everything being given without any issue. That is all available, number one. Secondly, the employers are required to set up what is known as a special pool. This is what I was trying to talk about. The gig workers, the platform workers like Zomato and others, where, for example, a special pool for these app-based workers, these special casual workers are being set up. Somewhere to the tune of 1% to 2% of the employers, the compensation is taken by the employer, and he would add his one compensation, his contribution to create that pool, which will definitely go to a large extent in helping building, reshaping, restructuring the finances of these workers who, at the earlier point of time, they were only thought, for example, in these platforms, whenever any incident happened, well, the most famous argument was, well, they are basically independent contractors. They have applied for this, and we have never forced them to apply. They have applied, and we are providing them a service. They are utilizing that service and making money. So if that Zomato or Swiggy worker meets with an accident and dies or is seriously injured, the employers would say no. But now that is not possible anymore. They will have to be suitably, adequately compensated as part of this social security net and other, allied laws like ESIC, that's Employee State Insurance Corporation. The necessary medical facilities which are given to the recognized workers, the regular workers, are also to be extended to such people, so on and so forth. Health examination after 40 has been sort of now been made available to all of them, whether you are a permanent employee or any other employee, with clearer shift schedules, which I did mention earlier. Well, these are some of the important promises. I think, we can think of some of the important developments that have taken place with the introduction of these new codes. But the real question is whether these points are in any way going to help, or have they been important enough to such an extent that all the ills of the earlier uh, employer-employee relations, have they been basically addressed? This is where I felt that the codes, the labor codes, they seem to be, from a distance, yes, it's like a mirage, I must say. From a distance, it appears to be, yes, there is water, but when you go near there, you see that there is no water. Well, why I have been thinking on these lines is because I am trying to look at the fallacies, the broken promises, or the broken expectations, so on and so forth. So let us see how vis-a-vis these basic promises, which appear to be very rosy, are hitting the labor force on the other side. The most important argument that is advanced is these new labor codes have not considered the soul of the earlier labor law jurisprudence at all. If you consider, for example, the by now iconic case, the monumental judgment, and of course the all-pervading, all-comprehensive interpretation given by Justice Krishna Iyer in the famous Bangalore Water Supply and Sewage Board versus A. Rajappa and another in 1978, where Justice Krishna Iyer elaborately interpreted the term industry with his now famous interpretative exercise called the triple test. And those of us who have ardently studied labor law would know how that triple test in fact changed the landscape of labor jurisprudence in this country. It is something on par with the basic structure theory advanced by Justice H.R. Khanna in the area of constitutional law. It is no less than what the basic structure theory holds for constitutional law students. For labor law students, Justice Krishna Iyer's triple test became the gospel to start with and the gospel to end with. Why? Obviously, the triple test enlarged the scope and horizons of industries to such an extent that almost anything where, because of that triple test, where there are employers and employees, and by virtue of the cooperation between them, they work to produce goods and services. If these three criteria were met, well, it was supposed to be an industry as advocated by Justice Krishna Iyer. So much so that universities, hospitals, even altruistic and philanthropic institutions, they all became industry and helped millions and millions of at least the organized workers. Of course, we all know that teachers were never considered as workmen because our profession is supposed to be a noble profession. So we were not either workmen nor were we employers. We were noble souls, noble messengers. But it helped a lot of, class C, class D, group 3, group D, non-teaching, administrative staff in places like universities, hospitals, so on and so forth, to get at least the entry into what is known as the otherwise great labyrinth of or the maze of law called the Industrial Disputes Act 1947. All students of labor law, which includes teachers, the regular students, the lawyers, the judges, everybody, I think they should be thankful to Justice Krishna Iyer's remarkable, judgment pronounced in this case, which brought almost anything under the sun in the purview of the term industry, except probably the truly, strictly speaking, sovereign functions of the government. And that's how we know that in many cases, Hospital Mazdoor Sabha, University of Delhi versus Ramnath, so on and so forth, all of them were, considered to be industry. Now the question is whether the new courts have retained this interpretation of industry intact to help not just organized workers, but the unorganized workers. And if you look at the definition under the Industrial Relations Code 2020, you will not be fully happy. We will be disappointed to see that Justice Krishna Iyer's interpretation is not fully adopted into the new code. It has been watered down. Although the triple test is maintained somewhat verbatim, but many altruistic, philanthropic organizations are kept out. Many governmental activities are kept out because maybe the draftsman felt that this interpretation would not hold water in the current scenario of liberalization, privatization, and globalization. That it might not be a very conducive way to look into, the idea of labor jurisprudence. But that is where the problem begins. Because if the term industry is not given that same interpretation which was given by Justice Krishna Iyer long back in 1978, then obviously whatever jurisprudence that is built around this concept will dwindle, will brittle down, and naturally it leads to diluting of the very coherence of the labor jurisprudence. Now, does that mean that those who are now part of the new labor codes would not be covered in much the same way as they were covered by this interpretation? Well, yes, to some extent, because the interpretation is sort of tapered down. But what I am seeing as a further troubling scenario for workers for the interpretation of the term industry is, in case the 9-judge bench, which has heard the matter in the Honorable Supreme Court about revisiting this term industry and the interpretation of Justice Krishna Iyer of that, in case this Honorable larger bench comes to the conclusion that Justice Iyer's interpretation would have served the idea of social justice that was prevalent in the 80s or the early 90s, but the post-90s neoliberal jurisprudence would not fit into the idea of industry as advocated by Justice Iyer. I think this might prove to be a little quicksand for the very labor law jurisprudence that has been built over hundreds of years in the rest of the world, and from which we have borrowed and built it in the last 100 years. Of course, the judgment is reserved, so we are not yet in a position to know what the Honorable Court is going to say about it. But if I visualize a scenario wherein this 9-judge bench would overrule fully or partially, or let us say would dissent with what Justice Krishna Iyer and his brother judges had held at that time, well, it might not be a very strong point for the laborers. Well, would that be a strong point for the employers? Well, from one point of view, yes, but from the economic point of view. But whether from the point of view of maintaining the required balance in the arena of industry between employers and employees or workmen, well, whether that would help it do so, that could be a debatable point. We don't know. We will have to wait and see. But what I am trying to tell you is, from 2 points of view, the very idea or notion of industry has now come under severe examination. One, of course, is by the dilution of the term industry as it is obtained in the new code, and one probably, as I said, in case a contrary opinion comes by the larger bench. If, on the other hand, the larger bench were to hold that Justice Iyer's definition is a profound one and it need not be tinkered with even after these 40 plus years, well, for all the pending cases under the Industrial Disputes Act, the workmen would definitely have, they will get a lot of advantages, but it might prevail upon the lawmakers today to also tweak in the definition of the word industry to probably go in with the philosophy advocated by Justice Krishna Iyer. Anyway, that is one major point which I thought we should keep in mind when we consider whether the kind of promise that was made or that was shown has really not been adhered to. That is number one. The second most important point is issues like laying off the workmen. Well, I think there definitely the earlier jurisprudence has been tinkered with to a great extent. We all know that in earlier Industrial Disputes Act, when there were 100 or more workmen and they were to be laid off, obviously the permission on the part of the appropriate government was mandatory. That helped the workmen to, sort of hold their ground, not being bullied by the employers or not being, terminated at the whims and fancies of the employer. And obviously, if they wanted to lay off, they had to give notice, take the permission of the appropriate government. But now the new code has made those numbers into 300. In other words, if an employer minds, he can lay off if there are less than 300 workers in his establishment without asking for any permission of the government. All that he can do is to inform them and do it. That's all. He need not, sort of follow the same elaborate procedure as he was earlier required to provide. And this threshold of 300 numbers is a dangerous trend. Because on the one hand, as we saw, as we discussed, many social security benefits are being extended. But on the other hand, when it comes to the Industrial Relations Code, well, the very essence of labor jurisprudence is being removed. So, to what extent this will dilute the very trade union movement, their integrity, their dignity, we have to wait and see. But the prima facie interpretation is yes, definitely it is going to, affect the workers to a very great extent, and whatever benefits that are promised under social security and other legislation, well, they are going to be, sort of removed. This is the second point. The third important point is under the same Industrial Relations Code, with reference to same laying off and other things. Earlier, there was a provision which compelled the employers to consider these workmen to be put in the alternative employment that he had, and the what we call the Contract Labor Regulation and Abolishment Act 1970 also provided that they could not be simply, abolished. They had to be regulated, and alternative sources were made applicable. But see, you will have to understand the chronological developments. In the year 2001, in the matter Steel Authority of India and others versus National Union Waterfront Workers and others, which was sort of delivered on 30th August 2001. In this case, the apex court had held that even where contract work in an establishment was abolished, the workers did not have automatic right of absorption, as was the basic spirit of that act. And obviously, with this new Industrial Relations Code, there is no more Contract Labor Act now. That is not part and parcel of the Industrial Relations Code. So, what we can now see is, as critics have argued, a system of temporary permanent workers. I repeat, we can see a system of a temporary permanent workers. So they are permanent so long as they are there, but they may be, simply laid off because the employer is going to restructure. In fact, this might give an opportunity to the greedy employers to think of offshore companies, shell companies, remove workmen, restructure it, bring it around 250. If he had, for example, let us say a workforce of 500, he can divide it into two, make it 250, and not be bothered about laying off at all. And remember, for this, he need not take any permission. He has to just inform them. There is no question of taking any such kind of permission. So that is basically, a drawback which might, not augur well for the labor force. The third point that I thought I would highlight is the wage regulation. When you look into the wage regulation part, we all know that the minimum wage and others flow from Article 43 of the Constitution of India, which speaks about a living wage and conditions of work, ensuring a decent standard of life, so on and so forth. And we all know earlier there used to be tripartite, consultative process for revision of wages and tag it with the inflationary trends, so on and so forth. But in the current codes, the point is the new national floor wage is contemplated instead of the term minimum wage. Now, we do not know whether this new national floor wage could be on par with the minimum wage, or it could be lesser than the minimum wage, and how or what parameters are going to be used. Because even when 20 years ago, whenever the question of wage revision was discussed or was being followed, it really wasn't a very conducive idea of how to go about this, because the very parameters were, earlier they used to contend that the parameters were very old from pre-independence time. Then post-independence, some committees did try to come out with parameters, but anyway, nobody was happy. And we all know how different terminologies were used. Uh, Minimum wage, living wage, fair wage, so on and so forth. Whether the idea of coming up with a national floor wage would be a happy substitute for minimum wage, or would it be lesser than minimum wage? Would it in any way really affect the workers? Well, you will have to wait and see and find out what is the idea. The next point, sorry, I'm sorry. Yeah, somebody is asking something.
No, sir. No, sir. You can
No,
continue.
sir.
Okay.
No, sir.
Yeah. And the next important thing is, sorry, yeah. Another important thing is, or probably the most important, seen from the point of view of workers, is their power of collective bargaining. Without this power of collective bargaining, well, admittedly, there is nothing left for them. More or less, the basic principles have remained the same. 7 workers can have a union, and 10% of representative union should be members, so on and so forth. But there is an added rider there that for the purpose of negotiation, 51% of the workforce must be in agreement with that union to give it the representative capacity of negotiating with the employers as a single negotiating union. Earlier, of course, such condition was not there, although the other conditions were there. But now the idea or notion of a single negotiating union has come up. And what if this 51% of workers are not really, supporting a union, a single union to negotiate? Well, then there is an alternative provision or remedy for a council of negotiating unions is also contemplated. The point is like this. When in the 70s and 80s, with politically backed unions, the workers still could not get a fairer representation. Politically backed unions in the sense, because at those times we all knew that the trade unions could spend a certain particular percentage of their finances for political purposes. They could go to elections, they could participate in elections, they could support the elections, so on and so forth. But these days in this new codes, that thing is explicitly not available. So the very idea of workers having the necessary political force or political support is not there. In the absence of that, it is quite possible that the trade union leaders would not get that necessary immunity from criminal conspiracy, which was one of the basic foundational advantages that they had. Because again, the present codes aren't, explicitly mentioning about all those things. So it is not really forthcoming for the workers to see whether they would be adequately politically represented to such an extent that that their views would be taken up strongly by that necessary force. Yes, for the purpose of negotiation, there is a union, but whether that union would be a tiger without teeth, would it be a teethless tiger? Well, only time can tell, because all these courts have just come into being, and we have to wait and see what kind of different interpretations the courts would give to them. But as I said, the prima facie reading would indicate that the negotiating capacity, the collective bargaining capacity, and the workers' basic strength in not being victimized or persecuted for their activities, their political activities, in help their trade union comrades, well, all those things don't seem to be there. So would that in what way affect the labor jurisprudence? Well, that is basically a very tough question to answer, as I said, because rules have been just recently framed, and to what extent the rules would be interpreted, to what extent they would help the workers. Well, these are all questions that have to be, looked into maybe with the passage of time. But my point is here something like this. There are, of course, many benefits being considered, being given by the courts, especially the social security courts, on a vast canvas. You can see that different colors are being used to make the painting. But when you go nearer that, they all seem to be reflecting only a white color. I mean, of course, I have always been a student with a strong pro-labor orientation. So obviously, anything that is done or purported to be done to water down the pro-labor legislation, well, it definitely troubles me. It definitely affects my way of looking at the newer things. That doesn't mean that the labor law jurisprudence can remain intact as it was in the 60s or 70s. But what is required is a law has to be made in such a way that it has to help everybody. You cannot, selectively help few and leave others, or you cannot give, let us say, majority benefits to some and minority benefits only, or minority wrongs only to others, like laborers and employers. Well, that might not augur well. They have to be properly balanced. But as I said, I'm not saying that the earlier labor laws were all goody-goody and they had ushered in a very great Ram Raja or utopian state. But the kind of interpretation given to those definitely enabled the workforce to fight for their rights. But now, when you put the so-called benefits which are given by the courts in juxtaposition with the dilution of their political and civil rights that were given to these various trade union members, the workers, and the fact that another thing I forgot to mention was about strike. Of course, I'm sure you must have remembered. Even now, these days, going on strike under the new codes is not that easy. It wasn't easy earlier also. In fact, if you had sat and calculated how a worker could have gone on strike even in the earlier scenario, well, you would have definitely had, headaches. But now, if you look into the new codes with that 60 days notice, well, it is anybody's imagination as to how a worker can, with that broad 60 days notice, even think of going to strike. And secondly, if during that particular time, or for example, again, I'm sure you must have read cases where instead of going on strike, the workers, they used to apply for a casual leave en masse, and they were held to be not amounting to strike, thereby protecting the workers, from the prosecution. But now, if they simply apply for leave, let us say all the 50 workmen, that would still be considered as an illegal strike, for example, in the new codes. So it is not that easy now to even try to address their issues by the only weapon, by the only tool they had, and that is the right to go on strike. Well, whether it could be called a right at all in the present days, that itself is another debatable point, because again, as I said, after the 90s, there has been a lot of legal changes, interpretations have changed, and courts have held that there is no such right as right to go on strike. But whether that interpretation would be and should be made applicable to the workers whose only potent weapon was strike, well, these are the questions when you put them in juxtaposition with the benefits. Well, I think this is not a very fair deal to the workers, although the benefits have definitely brought within the fold many more workers who are unorganized, the gig workers, the platform workers, so on and so forth. But the kind of benefits or the volume of benefits given is so small, I am tempted to say it is just like this. When you are poured, let us say, your favorite whiskey in a wine glass, well, I don't think you are drinking whiskey, because whiskey has to be taken from whiskey glass. It cannot be taken from a wine glass. Or to put it in a more formal way, when you put a cart in front of the horse and expect the horse to draw it, well, I think we are making a big mistake. In my opinion, these codes are just like that. They are trying to give us something, but they are not very comprehensive and convincing enough to bring certain things to the workers in such a way that, see, whenever you come out with new laws, whenever you repeal the old system, the new system has to be more convincing than the old one. If not, there is no point in repealing that and coming out with something new. But as I said, we have to give the benefit of doubt because they have just come into being. We have to see ultimately how they will be implemented, how they will be interpreted, basically. But by the looks of it, I mean, they do not seem to be, they do not augur well. That's how I have been, sort of studying them. Well, I think I'll stop at this juncture. These are some of the points I thought I should discuss with you, share with you. Well, if you have any questions, well, you can certainly ask the questions.
Yes, sir. Thank you. Thank you for your valuable insight about prophecies and fallacies of the labor codes. Sir, there are some questions in the chat box.
Yeah, please, sir.
Yes, sir. Vijay sir has a question regarding raising the threshold for retrenchment permission to more than 300 workers enables employers to terminate workers more easily. What is your opinion, sir?
Yes, sir. That's what I said. It is a retrograde or regressive step. I already said that. Because obviously it gives the employer a free hand to lay off people easily because of two things. Number one, the required benchmark is increased. So earlier it was pegged at 100. So more than 100 means he could not have laid off easily without permission. Now there is neither permission required and he could easily going to lay off 299 without permission, without even any valid reason. So that's what I said. It is in another way, sort of diluting the the workers' spirit. That's what I said.
Yes, sir. Thank you. Netra madam has a question. Does Ola, Uber, Rapido drivers comes under the scope of gig workers?
Yes, as per the prevailing trends, if we consider the Zomato and Swiggy and such other workers as such, um, obviously they are also coming. But the only point is, do they really get the opportunity to understand all these? Because most of these people who work in Ola, Uber, except probably those disgruntled and unhappy IT guys who are fed up with their IT jobs of paying lakhs, and they have come to streets now driving Ola and Uber, as we see in some of the news, news channels or somewhere here and there. But for them, others are still those rustic, illiterate people who will never understand the implications of these so-called benefits that quickly. That's why I told at the end that it all depends on the implementation and interpretation. So yes, they are covered, but would they be real beneficiaries? That only time will tell.
Yes, sir. Jaykumar sir has a question. Does the recognition of gig workers and platform workers guarantee social security in the context of prophecies and fallacies in New Labor Codes 2020?
That's what there are promises to them. As I said, there is social security. They are supposed to get the benefits under ESI Act. They can go to employee state insurance corporation hospitals like the regular workers and get the necessary medical checkup, health checkup, treatment. But the point is, the resources are already stretched attending to regular workers, regular recognized workers. Now to that we are adding another 560 million workers, but are we adding the resources to them? That nobody is talking of. Because the courts will not tell you about all these things. These are the things which the economists will tell or the policymakers will tell. So unless those resources are added, to what extent these promises in black and white would definitely help them? Well, that's only a question of time. Time has to tell that.
Yes, thank you, sir. Sir, Dr. Prakriti has a question. What
Yeah.
are the suggestions about effective implementation of labor codes to ensure job security to gig workers?
Sir, job security is there now because they are also supposed to get the employment letter. their shift schedules are to be given, what is the payment that they are going to get, that has to be given, what contributions they are going to make, and what contributions the platform owner or the app owner or whoever is involved has to make. Everything is going to be given. So from that point of view, yes, there is security, no doubt. But would that be implemented in full spirit? That, as I said, we will have to see. This is only a theoretical framework now. To what extent this theoretical framework would be implemented by all concerned, it takes, a lot to understand. See, I'll tell you, long years ago, I had read about a case from the Australian High Court. We all know that in Workmen's Compensation Act, there is what is known as injuries during the course of employment. And what exactly is meant by during the course of employment was a big question, because, for example, if a worker who is coming to an industry, let us say by using a public transport, he meets with an accident, whether the industry, the employer is liable to pay him a compensation because he was using that particular transportation to come to the industry for his work. Initially, the court said no, because public transportation is not given by the industry fellows. He was using public transport and it was his problem. Then a question similar to that one came, if the same guy meets with an accident when an industry provided bus, for example, meets with an accident. Then also there were differing interpretations when it was said that, if he is taking that bus and he is supposed to take that bus, yes, the employer is liable to pay. And a differing interpretation came when it was said that if an alternative route was available for him, alternative transportation was available to him, well, we cannot consider it as employer's liability. Then finally, it was also said that if he was required to travel in that particular bus, by example, by that employer only, then he has to give, the necessary compensation. There was an interesting matter which had come up from the Australian High Court. A man and a woman, employees of a particular company, they had to travel on company's job to another place in Australia. And when they went there, they were required to stay for a couple of days, 2-3 days. And the man had a sort of infatuation with the woman colleague, and they were deeply involved in a romantic relationship. Unfortunately, it so happened that after one romantic encounter, the man could not, sustain physically, and he died. Now, the family members of this man claimed compensation from the employer that he died in the course of the employment. In a situation like this, in a country like India, imagine some 20-25 years ago, the courts would have said, no, this is not acceptable, because in our society, such things are not heard of, and there are strict rules for employees, that they should not have relationship between themselves, so on and so forth. Of course, the Australian High Court also noted all the same things and said, notwithstanding all these rules, especially between the employees, the fact that these two employees were required to be in that place was by virtue of the employment. And the Australian High Court regarded that as a notional extension of employment to give the necessary compensation to the deceased workman's family, and the employer was required to shell out the money. For a very traditional mind, such an interpretation some 20-25 years ago would have seemed to be, how can even societies think like that. I mean, if that fellow was in love with that woman, that is his personal problem. Why should the employer pay for that? But the court thought otherwise. The court said, see, but for your employment, they wouldn't have gone there at all. That is the first problem. And so it was regarded as notional extension of employment. Now, whether such liberal interpretations would come after these codes are introduced and implemented or not, well, that is a question only time could tell. But yes, it depends. As I said, it all depends on how they are going to be implemented. I think we'll have, it is just 1 year now after full implementation, more or less. So let us see as and when the matters reach the Honorable Supreme Court or various high courts, we will come to know what the honorable judges would also be thinking about these things, especially in light of the LPG.
Thank you, sir. Dr. Mamta Misra has a question. My LLD topic is unorganized female workers, social and financial security rights. Any law regarding this? This was the question.
Well, madam should pay me my labor wages to give her all these details. Madam, you are doing LLD. I think you should discuss this with your guide rather than me, because again there would be different opinions that I don't even know what exactly is the idea that you are pursuing. All that you have given me is some rough title.
Yes, yes,
Uh,
sir, yes.
yeah, but of course, we can discuss this.
But I need your guidance and suggestion and
Sure, ma'am. You can talk to me personally rather than on this platform,
yeah,
so
yes,
that
sir.
we can definitely discuss this.
But I think just now you told us that teacher does not come under the definition of workman, sir.
Teacher is not a workman.
So you cannot be
No.
asking for.
Teachers are intellectual, not a worker, not a
Madam, I am
yeah.
not asking her as a workman. I am asking her as a super guide.
Yes, sir.
And she is not going to be my employer to pay me my wages. So it is basically, I am demanding the wages because she is supposed to seek help from me. So,
We
but
are
your point is
intellectuals,
well
so
taken.
we
I think,
should know which is the right word.
yeah, I think you can speak to Dr. Bhuneshwari. She will share my
Yeah.
details
Okay,
with
okay.
you. She
So
was
your
also
lecture is very effective and very knowledgeable.
She
Thank
was
you.
Very pleased.
also a student of mine once, so I think Madam knows she has my details, and you can
Okay,
definitely
sir.
talk to her. But
Sure, sir,
Dr.
sure.
Bhuvneshwari, your point is well taken, that teachers are not workmen, and they are not workmen even today. So you have to do something now. Prevail
Sir,
upon
that
the.
question is raised by not by me, sir. My colleague, Dr. Sumitra is there, sir.
Yes,
Oh,
So
sir.
I see.
yeah.
Thank you for the lucid discourse,
Ah.
sir. Very nice. Very good.
We are
But
big backbone of the society and country.
yeah,
Yeah, with those great words only, we have been duped all these years.
yes, sir. Yes, sir. In fact, when the labor code was implemented or it was on the annual, it was introduced with lot of fanfare and altruistic motive. But after listening to your discourse, we feel that they're only showing us the sun and the stars and the moon. I doubt if we can fetch any of them to the earth.
Uh, no, ma'am. As I said, let us wait and see. As I said, the bare reading of the courts, well, is not very promising, considering the political and legal aspects of the trade union jurisprudence. But from the point of view of economic aspects, economic benefits, well, they seem to be offering some good things. But mere economic things would not help you. That's why I gave you the example of that nice whiskey in a wine glass. It won't really give you that necessary pleasure. So, well, we will have to wait and see. Let's see.
Thank you, sir.
Sir, there is another question in the chat box.
Yes, sir.
How PF can be deducted when there is no specific wages to the gig and platform workers?
Sir, see, they are now saying they should be given the minimum that wage. It is being fixed, but it all depends. It may take some time. Rules have been framed, and these rules now require the governments to make that necessary wage fixation, but they are speaking about national floor wage without telling us what exactly is meant by this national floor wage, and whether this floor wage is minimum wage or it is less than that, it is more than that. There is no clear idea as to what exactly is meant by that. But yes, there is a provision to do that, but it takes time. We have to see. Once some of these things are put into motion, I think then we will be in a better position to comment on the actual impact. Now, this is all only, proposed impact. Now, this is what it might happen. This is the anticipated, or let us say visualized impact. What would be the real impact? That we will have to wait and see.
But sir, shouldn't the minimum wage be the benchmark for fixing the floor wage?
Sorry, ma'am.
Sh- uh, isn't the minimum wage a benchmark for fixing the floor wages?
Yes, but what I'm trying to tell you is that thing is not explicitly mentioned anywhere now.
Okay.
If you look into the code, it doesn't say that you must keep minimum wage as the necessary concomitant, or let us say as the touchstone to go with national floor wage, because they have not even explained what is meant by that. I would advise you to read a couple of papers by Professor Babu Matthew of National Law School of India,
Okay.
who has made a very in-depth study in all these things. I think if you can read those papers presented by Professor Matthew and his team, you will get more insights as to where these gray areas are lying actually, which probably only researchers like us can look into. If you give it to the draftsmen or the policymakers, they will only look at the outward facade. But inside, whether the citadel is crumbling or not, only the researchers can tell. So I think you will do well to read those different papers
Yes, sir.
written by him.
Thank you, sir.
Yeah.
Sir, can I add some point regarding minimum wage and floor wage?
Yes, sir. You can.
Sir, floor wage and minimum wage is two different concepts, and
Okay.
floor wage will be decided by the central government based on skill set or geographical area or both.
Yes.
And appropriate government still can they shall fix the minimum wages, but only condition is that minimum wage shall not be below the floor wage fixed by the central government.
Okay.
And the appropriate government shall revise the minimum wages based on the consumer price index changes.
Okay. Now there are two things here. One is you said their skill set and other things. Now, do you think these gig workers and others have the necessary skills to show that they deserve this much minimum wage or floor wage? Number one. Number two, what is being provided in the way of augmenting their skills throughout these codes? Well, there is no clarity. Number three, central government shall fix the floor wage. The question is, what is the floor wage? Has it been defined? Has it been explained? They say, yes, national floor wage has to be given, decided by the government. Fine. And fourth point is, notwithstanding that, appropriate government will or may fix or has to fix minimum wage. But would that minimum wage be same throughout the country, or would it differ from state to state? If yes, on what grounds? How are you going to fix minimum wage for gig workers? And how would that minimum wage be different from one gig worker to another gig worker? Well, there are no pointers for this. That's why I said there is a large skeleton made available to us. The flesh and blood is yet to come. Unless it comes, we cannot jump to the conclusion. But if you look at the skeleton, it doesn't seem to be that of a healthy person, is what I am trying to say. Thank you.
And sir, the category of workers will be decided declared by the central government. Actually, it was already there were there in the draft code on wages. About 7,050 categories was there, but now they removed in the final rule, and they are coming they are discussing with the state governments, and they will come up with the fresh deal list. So all the about 90% skill categories will be categorized in that list.
Yes, sir. So then what will the non-skilled people do?
No, they will come under unskilled category.
Sorry?
They will come under unskilled category.
That they will come under unskilled category, that is correct. But the point is, how are you going to fix this floor wage for both of them? On what basis? Is there any parameter there as of now?
No, sir, based on their skill set only government will categorize.
Correct, sir. My point is, if government starts doing all these things, then where is the guarantee that the workers' needs are met? It is for the workers to decide. No, they have to know what they want.
Yes,
Government cannot decide those things.
no,
See,
no.
government can decide UGC scale because we all know how much it comes to, and everybody is well off. But when it comes to workers, if the government fixes some wage, do you think that really is a matter of justice for them?
But sir, now also the same practice is happening.
Exactly. That's what I am also trying to say. I started in the beginning with the same argument. Neither the old legal system nor the new legal system seems to provide any succor to them. A law which is equitably balanced has to come, and this is the second attempt is also not an equitable one, is what I am trying to say. They should have come out with more cogent, more coherent laws with proper parameters. This is what I am trying to tell you.
But government can fix only minimum wages, like government
Sir,
cannot.
that is the problem, sir. Government can only fix minimum wage. Government can only fix floor wage. My question is, on what parameters or what criteria is it going to fix it?
Sir, based on the skill category of the workers.
Yes, sir. Skill category means what you think. See, for example, this person who goes on Zomato, what skill do you think he should possess now?
No, they will come under unskilled category.
Then what is he going to get? Instead of your unskilled category wage, he would be better off, driving his Zomato, getting whatever money he gets and goes off.
No, I'm giving you an example. If government is considering their driving skill, then they may be come under skilled category. We don't know that.
What driving skill is required there? He needs to have a license, that's all.
Yes,
You think is he driving an F1 now? No.
No, sir. Actually, driver comes under skilled category.
Sir, driver may be skilled category, but he has to carry so many things. Then he has to go and give it to them. There is a time gap, 10 minutes. There is a pressure on them. So what skills do you think they should possess for all this? If your order itself is delayed by 15 minutes, you will start shouting at them, which will put them under pressure. So how are you going to compensate? How are you going to decide all this under skills or unskilled? First, you must decide what is meant by that wage. No, then you can think of all those things.
Sir, thank you, sir. So we have, sorry, one more question from VS Balaji, sir.
Yes, sir.
Bilagi. It is an important question regarding teachers. Sir, with more private parties entering the education sector, it is high time we need to regulate the pay conditions of teachers in this private institution. Most of the teachers are underpaid. Other counterparts like bus driver carries a higher pay package than teachers. What is your take on that?
Sir, unfortunately, that is true, and Balaji sir has hit on the head of the nail. This everybody has been saying, but who is going to bell the cat? That is the most important question. But more than that, the question is, where is the cat? It is something like an exercise where a person is in a dark room, is trying to find a dark cat which is not there. That is the problem. But Balaji sir, you are right.
Bilagi.
Let us start
Yes,
the
Bilagi.
movement.
VS Beelagi, she's a madam, sir.
Oh,
She's
madam.
not
Okay.
sir, she's madam.
Yes,
Okay.
sir. Can I add to what you just said, sir?
Yes.
Mhm.
Yeah, that was my question only.
Okay.
Hello.
Okay. Please. Yes,
Am I
ma'am. Yes.
audible, sir? Am I
Yeah. Yeah.
Yes,
audible?
Please.
yes,
Please.
madam, yes,
Yeah,
madam.
yeah. My question is, right now in this group, many of the teachers are serving in private institutions or law colleges.
Yeah.
Yeah, so they don't have any other choice, that since they have become so, what my question is basically, you want to say the teachers are skilled, come under skilled labor force because of their education and etc.
No.
And
No.
you are
No. Teacher.
giving a
Teachers are
no.
not skilled also. They are, as I said, noble souls. Your job is to do and die and not to ask
But
why.
nobility does not fill our needs, sir. It does not suffice our needs.
No, no, no. I'm only trying to give you the interpretation given by others, ma'am. It is not my interpretation. I
Exactly.
told
So
you
my
right in the
question is,
beginning.
and let me tell you, the cat here in this case, we all know, but we don't want to speak about it. The cat is most of the times, if you look at all the private institutions, most of them, they are set by people who are already come as MLAs, MPs, etc.
No,
So
not
they
necessarily.
are the persons who are already having a interest. When they are making laws, they may make certain laws wherein you still the courts have to work around the clock to give different interpretations. I
Ma'am,
hope, sir.
it is not like that. It is not whether MLAs or MPs or
No,
whoever.
no,
The
most of them,
issue,
I'm just saying,
no,
sir,
no,
given
let
a
me tell
fact
you.
that most of the educational
Let
institutions
me,
are run by people with political
no, no,
backgrounds
let me
only.
tell you. See, the blame actually lies with us. When we
I'm just saying
actually,
educational institutions, sir.
yes, madam, that's what I'm saying. If we take your point that they are run by mostly the governmental functionaries or our representatives or whatsoever, which may not be the case in all cases. Point is, we we in the sense the electorate generally I am speaking, because uh, Plato says that you cannot complain that you are being wormed into accepting submission when at the required time you don't get up and challenge the people or challenge the system. We don't do all that. We don't do all that because we are in our comfort zone, most of us. And so we are not really bothered. If, see, it is something like this. If tomorrow there is a movement, if there is a, let us say, an organization which tries to come up with this to do something, do you think all will join in? No, because each one has his or her own problems. So it doesn't work like that. That is why best thing is, if anybody wants to achieve such things, you will have to take it in a legal manner. Go to the courts, go to the necessary legal forums, go to the elected representatives, come with petitions, go with petitions. That is how you should try to do it. Merely talking will never help anybody. There must be some proactive action there. Then only things can happen.
This is in addition to Madam V.S. Bilagi's statement. I think gig workers make more money than LLM and PhD, sir.
Agree to that, sir. I
That,
literally, I think.
that I think you have to ask Mr. Vishak or somebody who was thinking about the skilled works that, so, if I am not mistaken, it is Mr. Vishak. I am
Yes,
not
yes,
sure.
yes, sir. Yes, yes.
Yeah, I think, sir, I have taken enough time of yours. Should
It's
we
okay, sir.
stop
It's okay,
or
sir. Sir, questions are over
Sir,
now.
thank you, sir. Thank you, sir.
Vijay,
Thank you
sir.
for the discourse,
Yes,
sir.
madam.
Ah,
It's
sir,
really nice
it
to
has
hear
been
you.
my pleasure, and
Yes.
well, as I said, it gave me an opportunity also to brush up a bit on my new labor codes, because of only administrative responsibilities, reading has become a casualty these days. So you gave me actually an opportunity to actually, read, analyze, think. So thank all of you
Thank
for
you.
giving me this opportunity, and
thank you,
the
sir.
enthusiastic, lovely participants who made the discussion pretty animated, pretty contesting, and pretty challenging. Thank you. And if there are any, of course, uh, issues that we need to still discuss, well, the floor would be always open. You can reach out to me on my email, LinkedIn, and others. I hope to give you more satisfactory answers. Thank you, sir. Thank you, ma'am.
Thank you, sir. Thank you. Over
Thank
to
you.
you, Vijay.
Yes, sir. Yes, sir.
Yes,
May I
please.
request Ms. Dublina, Madam, Assistant Professor, Vivekananda College of Bangalore, to propose vote of thanks.
A very good evening to everyone present on today's session. It is my privilege to propose the vote of thanks on behalf of Vivekananda College of Law for this highly insightful session on prophecies and fallacies of labor codes. I extend my deepest gratitude to our eminent resource person, Dr. Sandeep Desai Sir, Professor and Dean, MIT Law School, Bangalore. Sir, your scholarly analysis of the labor codes, coupled with your practical insights and critical perspectives, has enabled us to better understand the objectives, challenges, and implications of the recent labor law reforms in India. Thank you, sir.
Thank you. Thank you.
Thank you, sir. I express my profound gratitude to our respective principal, Professor K.P. Kempegowda, sir, whose visionary leadership and unwavering commitment to academic excellence have made this faculty development program a cherished biannual tradition of our institution. Thank you, sir, for your
Thank you, ma'am.
inspiring leadership.
Thank you.
I extend my sincere gratitude to our program coordinator, Dr. Vijay, for his meticulous planning, dedicated efforts, and unwavering commitment in ensuring the seamless organization and successful execution of this faculty development program. Thank you, sir. I would also like to express my sincere gratitude to our IQAC coordinator, Dr. Bhuvaneshwari S. Kolaki, for her constant guidance, unwavering support, and invaluable contribution to the successful conduct of this faculty development program. Thank you, ma'am.
Thank you.
Finally, I extend my heartfelt gratitude and appreciation to all our esteemed participants, including our respective principals from various institutions and my dear colleagues, for your gracious presence, enthusiastic participation, and insightful interactions throughout this program. With sincere gratitude to each one of you, I thank you all for being a part of this enriching academic endeavor. Thank you, everyone. Wishing you all a pleasant evening. Thank you.
Thank you, madam.
Thank you.
Dear participants, we are pleased to inform you that the session scheduled tomorrow will be delivered by Professor Dr. Dasarath N, retired professor, University College and Department of Postgraduate Studies in La Bangalore University, who will be discussing on interplay between ease of doing business and planning workers' rights in the ways of code on international relations and analysis. So we looking forward to see you all tomorrow at the same time. Thank you. Thank you.
Thank you, sir.
Thank you.
Okay. Thank you all. Right. Bye, ma.
Thank you, sir. So thank
you,
Professor Dashrath, sir. He is already
Oh.
there in the session.
Sir,
Yes,
Professor Dashrath, sir. Good
Thank you,
evening.
Professor.
He was there.
Thank you very much for joining us.
I think he's listening. It's okay, sir. Okay.
He exited about some time back, so he was there in the meeting all this while.
Correct.
Okay, sir.
Okay.
Thank
Bye.
you so much.
Okay,
Thank
ma'am.
you.